Yes, may I start, please?
Yes, please.
Good morning again, everyone. This case management conference is in the matter of case number CFI 032-2023, 2021, and is being held by way of video conference before Her Excellency Justice Maha Mheiri. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's behalf. The claimant is represented by Aiken, and the lead counsel is Mr. Graham Levitt. The defendant is represented by Stephenson Harwood, Middle East, and the lead counsel is Mr. Awusika. Will the judge and the parties' representatives please confirm that the situation is as I have stated?
Confirmed for the claimant.
Confirmed from the defendant.
Thank you both.
Thank you. Mr. Graham, you will proceed.
Yes, Your Honour. I'm not quite sure how you do want to proceed. In terms of the history leading up to this case management conference, the parties had provisionally agreed to try and set a timetable for the immediate judgment application. And that's what I would propose doing at this case management conference. Very obviously, if the immediate judgment application is successful, which we're assuming it will be, then the case management conference and the further directions become irrelevant, become moot. If it's not successful, then the case management directions can be given immediately after that judgment. But I'm in your hands as to how to proceed. But given that there is an immediate judgment application, it seems to me to be a best use of the court's time to try and set what I would request as an expedited timetable for the summary judgment application. Now, there are a couple of things, Your Honour, that I would like to point out. First of all, the judgment in the commercial court. This is a very straightforward case of enforcing an English High Court judgment. The judgment is final and certainly binding on the defendants in England. And we are applying and have applied to have that judgment recognised in the DIFC against the defendants. Now, that judgment was given in February 2022, which is well over a year ago now, and it still remains unsatisfied. Now, it seems to be the defendant's case, and I'm sure Mr. Awasika will address you on this, but it seems to be the defendant's case that there is some spurious public policy reason or argument why this judgment cannot be recognised and then enforced in the DIFC, and then, of course, in the wider UAE and under the regional conventions. It would seem from the case management information sheet that a spurious argument in relation to public policy has been advanced, which I don't quite follow or understand it. But there's a couple of public policy arguments that have been advanced, which very clearly are an attempt by the defendant just to kick this case down the road. They wanted to continue not to pay, and now they're raising spurious arguments as reasons why they shouldn't pay. But these are questions. All they've done is raised questions of UAE public policy, and there is Court of Appeal authority. Now, what they've done is asked for this matter to be held over for a full hearing in January 2024, which is consistent with their desire to delay this case even further. What they've done is suggested that this is a matter that requires expert evidence because they've raised issues of UAE public policy. They haven't explained those public policy reasons. They've just raised them, and I can take you through them if you'd like me to do so. But they're complete nonsense. Effectively, what they're saying is that UAE public policy requires that foreign judgments are not enforceable in circumstances where a chief restructuring officer of the defendant company may be liable for criminal action for failing to look after the assets of the company. Now, clearly, that's absolute rubbish because a judgment can be enforced against any company. whether it's run by the chief restructuring officer or a director or a manager or a general manager, the judgment needs to be enforced. And there's no public policy reason in the UAE why that should not happen. The second point I'd like to make very clear is that there's Court of Appeal authority, and I can take you to the case, to the effect that for UAE governed disputes, and this is purely a matter of UAE public policy, the DIFC court and DIFC judges are well able to deal with UAE public policy issues. That's a Court of Appeal judgment. I can give you the citation, which is Fidel, F-I-D-E-L, and Felecia, that's F-E-L-E-C-I-A, and Faraz, F-A-R-A-Z, and that's a 2015 Court of Appeal decision 002, and that was a decision of Michael Huang, who's then the Chief Justice. Effectively, that decision says that for matters of UAE law, you do not need, and the court does not require, expert evidence because the judges very clearly are well versed in UAE law. So what we have here is a spurious argument based on UAE public policy designed to prevent and delay the enforcement of a perfectly enforceable judgment, trying to delay that even further by the suggestion that this is a matter that requires expert evidence. Court of Appeal authority says it does not, and we say that this is a matter that can be resolved expeditiously, quickly, by way of summary determination.
Okay, thank you. Mr. Osaka.
Good morning, Your Excellency. While we obviously disagree with much of Claimants Counsel's submissions, I don't actually have rights of audience before the DIFC court. So I'm not entitled to make submissions before this court. I'm reluctant to say very much more. We'd emailed the registry yesterday informing them of this, and we'd hoped that there would be a CMC, there would be a postponement of the CMC, but obviously understand that it's very short notice at this point. And we tried to find alternatives on short notice, but unfortunately weren't able to. So the purpose of my attendance today really is to apologise to the court and of course to Claimants Counsel for the inconvenience and if possible request a postponement of the CMC.
Okay, so here's what we're going to do. Let's deal with the immediate judgment application. As it's a heavy application, you will receive deadlines through email. Would you like this application to be dealt with on paper or in a hearing?
If you bear with me 1 second, Your Honour, let me just take instructions on that.
Okay.
Your Honour, our preference would be for a hearing.
Okay.
And we have filed our application notice. And so in effect, the clock has started to run on this particular application in terms of the timetable.
Mr. Graham, as we received confirmation of payment yesterday, you will receive the deadlines through email, as it's only has been confirmed payment yesterday. So you will receive further information through email and with a hearing date in relation to dealing with that immediate judgment application.
Thank you, Your Honour. And I do note from RDC 2344, just for the record and the court record, that the evidence in answer to the application needs to be filed 28 days after service of the application.
Yes.
Now, whether that is affected by the payment issue, and I think the payment was in fact made last week. So anyway, I think the expectation, I think, on the claimant side is that the hearing will come on relatively quickly.
Yeah. I'll just confirm this with the registry, and then you will receive further information through email.
Your Honor,
Okay.
Thank you very much.
Thank you both for your time. Mr. Osaka, you want to say something?
Thank you, Your Honour. No, just again to apologise to the court
No
for
issues. Thank you both for your time. Thank you.
Thank
Thank
you,
you.
Your Honor.
Goodbye.